Hi, I'm Bill Halstead, MSW, LSW, SWC. In this video, we're going to explore HIPAA and 42 CFR Part 2, two key rules that protect patient privacy and keep health information secure. Over the next few minutes, I'll walk you through the essentials, from what counts as protected health information to patient rights, exceptions, and what to do if there's ever a breach. Here's what we'll cover in this video. We'll start with an overview of HIPAA and its key rules for protecting patient information. Next, we'll look at protected health information, or PHI, and who must comply with these rules. Then we'll dive into the HIPAA security rule, breach notification requirements, and the minimum necessary rule. After that, we'll go through 42 CFR Part 2, including consent requirements and exceptions for disclosure. Finally, we'll review what to do in the case of a breach, the consequences of non-compliance, and a summary of key takeaways. By the end, you'll have a clear understanding of how to keep patient information safe and stay compliant. Let's start with HIPAA. This is a federal law that sets the standards for keeping patient health information private and secure. In the next slide, we'll break down what it covers, who it applies to, and why it's so important for healthcare. HIPAA stands for the Health Insurance Portability and Accountability Act, passed in 1996. It applies to healthcare providers, health plans, and their business associates. Basically anyone who handles patient information electronically. HIPAA establishes national standards to ensure that patient information stays confidential, accurate, and available when needed for care, treatment, or payment. It also gives patients rights over their own information, including the ability to access their records and request corrections. Following HIPAA protects patient privacy, maintains trust, and keeps healthcare organizations compliant with federal law. Before we dive further into the material, it's helpful to talk about effective delivery techniques for this content. When presenting HIPAA and 42 CFR Part 2, it's important to be clear, conversational, and use real-world examples to make the rules easier to understand. Visual aids like slides or diagrams can help illustrate complex points. Pausing to emphasize key points, repeating important rules, and engaging your audience with questions or scenarios can also improve retention. The goal is to make sure the information is not just presented, but understood and applied correctly in real-world healthcare settings. The HIPAA privacy rule sets national standards for protecting patients' health information, or PHI. It applies to health plans, healthcare providers, and business associates who handle this information. Key elements include giving patients rights to access their records, request corrections, and know how their information is used or shared. The rule also holds violators accountable with civil and criminal penalties. Overall, it ensures that PHI is used appropriately for treatment, payment, and healthcare operations while keeping patient information safe and confidential. Protected health information, or PHI, includes any information that can identify a patient and relates to their health, treatment, or payment for healthcare services. This can include things like a patient's name, date of birth, social security number, medical history, or payment information. PHI can exist in electronic records, on paper, or even be shared verbally. HIPAA ensures that all this information stays confidential, is only shared for authorized purposes, and that patients have rights over how their information is used. Essentially, if information can be linked to a patient and relates to their health, it's protected under HIPAA. Now let's talk about who must comply with HIPAA. Understanding who is covered is essential because these rules apply differently depending on your role. In the next slide, we'll break down the covered entities, business associates, and what that means for you. Now that we've covered who must comply, let's shift to how protected health information, PHI, can actually be used or shared. This section lays out the ground rules, when disclosure is allowed, when consent is required, and how to make sure that only the minimum necessary information is released. Understanding these principles is key to maintaining both compliance and trust with the people we serve. Protected health information, or PHI, can only be used or disclosed under clear, limited circumstances. HIPAA allows disclosure when it's specifically permitted by the law or when the patient provides written authorization. There are two main cases where disclosure is actually required. First, when a patient requests access to their own medical records, and second, when the Department of Health and Human Services conducts a compliance review or investigation. Outside of those, sharing PHI has to follow the minimum necessary standard, meaning only the information essential to the purpose should be shared. Keeping these boundaries in mind helps ensure that patient privacy and trust remain protected. Next, let's look at authorizations. When and how patients give formal permission for their information to be shared. HIPAA sets very specific requirements for what an authorization must include and when it's needed. This section helps clarify what makes an authorization valid and how it protects both the patient and the provider. Written authorization is required anytime protected health information is shared for reasons other than treatment, payment, or healthcare operations. In other words, if the disclosure doesn't directly relate to providing care, billing, or managing services, a signed release is needed. A valid authorization must clearly state the purpose of the disclosure, include an expiration date, and be signed and dated by the patient. These steps ensure that patients remain in control of how their personal information is used, and that disclosures stay within the limits of HIPAA compliance. Now let's talk about the minimum necessary rule, one of the core principles of HIPAA privacy. Even when sharing information is allowed, HIPAA requires that only the minimum amount of protected health information needed to accomplish the task is disclosed. This rule keeps privacy at the forefront of every interaction, whether it's a phone call, a report, or a record request. The minimum necessary rule means that when accessing, transmitting, or handling protected health information, you should only use the smallest amount of information needed to complete the task. This rule applies to all employees, regardless of role, and is designed to reduce the risk of accidental or unnecessary disclosure. By following this principle, healthcare professionals help maintain patient privacy, ensure compliance with HIPAA, and protect sensitive information from being shared beyond what is truly needed. Next, let's cover the HIPAA security rule. While the privacy rule focuses on protecting all forms of patient information, the security rule specifically addresses electronic protected health information, or EPHI. This section explains the safeguards required to keep electronic health data secure, accurate, and accessible only to authorized personnel. The HIPAA security rule focuses on protecting electronic protected health information, or EPHI. Its goal is to ensure the confidentiality, integrity, and availability of patient data. Covered entities and their workforce must implement policies and procedures to safeguard EPHI, identify and address potential threats, and ensure that everyone handling the data follows proper security protocols. By taking these steps, healthcare organizations reduce the risk of unauthorized access, data breaches, and errors, keeping electronic patient information safe and reliable. Now let's look at the HIPAA breach notification rule. Even with strong privacy and security protections, breaches can happen. This rule explains what steps must be taken if protected health information is accessed or disclosed inappropriately, and who needs to be notified when a breach occurs. Under the HIPAA breach notification rule, if a breach of protected health information occurs, certain notifications are required. Affected individuals must be informed, and the Department of Health and Human Services must be notified as well. In some cases, the media may need to be informed if the breach affects a large number of people. Notifications should generally be made within 60 days of discovering the breach, though it's important to report the incident to supervisors immediately. Prompt reporting helps ensure the breach is managed quickly and in compliance with federal law. Next, let's talk about enforcement and penalties. HIPAA isn't just a set of guidelines. There are real consequences for failing to comply. This section covers how violations are handled, who enforces the rules, and the potential civil and criminal penalties that can result from noncompliance. HIPAA violations can result in both civil and criminal penalties. Civil penalties can range from $100,000 to $50,000 per violation, depending on the severity and circumstances. Criminal penalties increase with intent, up to $50,000 and 1 year in prison for knowingly violating HIPAA, up to $100,000 and 5 years if the violation involves false pretenses, and up to $250,000 and 10 years if the intent is to sell or misuse protected health information. Enforcement is handled by the U.S. Department of Health and Human Services Office for Civil Rights, which investigates violations and ensures compliance. Now we're shifting to 42 CFR Part 2, which specifically protects patients receiving treatment for substance use disorders. This rule is designed to maintain confidentiality, reduce stigma, and encourage people to seek treatment without fear of their information being disclosed inappropriately. In the next slide, we'll explore the details of what it covers and how it works. Now we're shifting to 42 CFR Part 2, which specifically protects patients receiving treatment for substance use disorders. This rule is designed to maintain confidentiality, reduce stigma, and encourage people to seek treatment without fear of their information being disclosed inappropriately. In the next slide, we'll explore the details of what it covers and how it works. Next, let's talk about exceptions to consent under 42 CFR Part 2. While patient consent is usually required to share information, there are certain situations where disclosure is allowed without it. In the next slide, we'll go over these exceptions and when they can be applied. Under 42 CFR Part 2, there are specific situations where patient information can be disclosed without consent. These include medical emergencies where immediate action is needed, reporting suspected child abuse, and incidents involving crimes on program premises or against staff. Court orders signed by a judge also allow disclosure, as do communications with qualified service organizations, or QSOS, that provide services to the treatment program. These exceptions are narrowly defined to protect patient confidentiality while addressing critical safety, legal, and operational needs. Now let's discuss breaches under 42 CFR Part 2. Even though this rule provides strong protections for patient information, unauthorized disclosures can still happen. This section covers the potential consequences of breaches and why it's crucial to report any suspected violations immediately. Unauthorized disclosure of information protected under 42 CFR Part 2 can have serious consequences. Patients may face civil and criminal penalties, loss of employment, housing, or child custody, and even discrimination from medical professionals or insurers. I used to work as a medical case manager at an AIDS services organization in Denver, Colorado. In the past, when a client with HIV or AIDS requested rental assistance, the check sent to the landlord often included the word AIDS, and this would lead to some instances of discrimination against the client. Fortunately, this no longer happens with that agency. Because of these risks, it's essential that any suspected breach be reported immediately to the appropriate authority. Prompt reporting helps protect both patients and staff and ensures compliance with federal regulations designed to safeguard sensitive information. Finally, let's go over the proper actions to take if you suspect a breach of HIPAA or 42 CFR Part 2. Knowing the right steps to follow can prevent further disclosure, protect patients, and keep your organization compliant with federal regulations. If you suspect a breach of HIPAA or 42 CFR Part 2, the first step is to notify your immediate supervisor. Your supervisor will then inform higher management and the compliance team. It's important not to contact the patient directly, as this could complicate the investigation. All actions taken should be carefully documented according to organizational policy. Following these steps helps ensure that breaches are handled promptly, appropriately, and in compliance with federal regulations protecting both patients and staff. To wrap up, both HIPAA and 42 CFR Part 2 are federal rules designed to protect patient privacy and ensure the security of sensitive health information. HIPAA governs all forms of protected health information, giving patients rights over their records and requiring strict rules for use, disclosure, and security of information, including electronic data. The minimum necessary rule, security rule, and breach notification rule all work together to maintain confidentiality and prevent unauthorized access. 42 CFR Part 2 provides additional protections for patients in substance use disorder programs, requiring consent for disclosures except in narrowly defined situations, and emphasizing confidentiality to reduce stigma and promote treatment. Violations of either law can result in serious civil and criminal penalties. Always follow proper reporting procedures for suspected breaches, use information responsibly, and protect patient privacy at every step. Thank you for taking the time to go through this overview of HIPAA and 42 CFR Part 2 with me. I hope this presentation has helped clarify how we protect patient information, understand the rules for disclosure, and respond appropriately to potential breaches. Protecting privacy isn't just a legal requirement. It's essential to maintaining trust with the patients we serve. If you have any questions or need further clarification, please feel free to reach out to me. My name is Bill Halstead, MSW-LSW, SWC, and you can contact me at whalstea@mail.yu.edu. I appreciate your attention and dedication to maintaining the highest standards of confidentiality in patient care.